Hello, everyone. This is Richal Maddow, and I need you to listen closely because what just happened in Washington changes everything. In the last few hours, a federal judge issued an order so blunt, so direct, that Trump's legal team went from confident to scrambling in real time. This isn't rumor. This isn't a sources say situation. This is official records. This is a courtroom move that forces testimony into the light with deadlines attached and consequences that don't care about politics. And tonight I'm looking at sealed filings and internal correspondence that were never meant to be read out loud. Before we go any further, do me a favor, subscribe right now and stay with me until the end because the next few minutes are going to connect dots most people aren't even looking at. Watch closely. Listen closely. This one is not going away. Now let's talk about what just happened because the headline is simple, but the mechanics behind it are devastating. Confirmed, judge demands testimony. Trump's legal team in panic mode. And when I say confirmed, I mean confirmed in the way that matters. Not through talking heads, not through viral clips, through the kind of paperwork that ends careers, through the kind of language that only shows up when a court has had enough. This isn't just a judge asking for more paperwork. This isn't a polite request. This is a demand for testimony under oath tied to a timeline that cannot be spun. And the reason it matters is because testimony is where stories die. Testimony is where I don't recall becomes a trap. Testimony is where the paper trail catches up with the performance. And tonight, I'm going to walk you through the chain of events slowly, carefully, because the details are what make this explosive. I'm looking at a filing time stamped 09:17 a.m. And the first thing that jumps out is the tone. It's not emotional. It's not political. It's clinical. It reads like the court is saying enough. We're done playing games. There's a section labeled compelled appearance and production. And it lists names with the kind of formatting you only see in serious litigation. Some names are public, some names are partially redacted, and one name, one key figure, is listed as witness A. That tells me something very specific. They're protecting the witness, not because the witness is unimportant, because the witness is dangerous. Let me read this word for word. The court finds the requested testimony is material, non-duplicative, and necessary to resolve outstanding factual disputes. Read that again. Material, non-duplicative, necessary. That is a judge telling you in legal language that someone has been dancing around the truth and now the music is stopping. Then it gets sharper. The parties are ordered to present live testimony and contemporaneous notes, including internal correspondence by the deadlines below. Contemporaneous notes, internal correspondence. That phrase right there is not accidental. That phrase is a court reaching into the back room where the real conversations happened. Because here's what you have to understand. Public statements are crafted, press releases are crafted. But internal correspondence, that's where people talk like they think no one is watching. That's where panic shows up. That's where guilt shows up. That's where the truth shows up. Now, why would a judge do this? Why would a judge force testimony when everyone knows testimony creates risk? Because the court believes there is a factual dispute that cannot be resolved through written arguments, meaning somebody's lying or somebody's hiding something. And the court is done pretending it can be solved with clever lawyering. Now, the most revealing part of this isn't even the demand for testimony. It's the reason. There's a paragraph buried in the middle of the order, and it references something called prior representations to the court. That phrase is courtroom dynamite. Prior representations to the court means someone previously told the judge something, either directly or through filings, that the judge now suspects may not be accurate. And when a judge suspects that, that's when the gloves come off. Because courts do not like being played. They do not like being misled. And they do not like realizing they were handed a story instead of facts. Now, I want you to picture what this looks like behind the scenes. A legal team that thought it had the timeline under control, a legal team that thought it could keep everything in the realm of motions, objections, delays, and suddenly a judge is saying, no, no more. Bring the people in. Put them under oath. And let's see what happens when the questions are asked out loud. That's why this is panic mode, because panic mode isn't about the headlines. Panic mode is about what they know will be asked and what they know they can't answer cleanly. Now, here's what sources close to the matter describe as the frantic scramble that started the moment this order landed. At 11:42 a.m., just hours after the judge's demand, there's an internal email chain flagged urgent and marked privileged and confidential. And yes, that label matters because people only stamp that on something when they're afraid. The subject line reads, "Witness prep immediate." Inside, the tone is clipped. No pleasantries, no hope you're well. Just a message that says, we need to align on the timeline. Court is demanding live testimony. We cannot have surprises. Read that again. We cannot have surprises. That is not the language of innocence. That is the language of damage control. And it gets worse. A reply comes in 7 minutes later from someone whose name is redacted, except for the first letter, M. And it says, we have a problem with the dates. The notes don't match the statement. The notes don't match the statement. That's the moment the room goes quiet. Because if the notes don't match the statement, you don't have a misunderstanding. You have a contradiction. And contradictions are deadly under oath. Now, let's talk about what those notes might be. Because the court didn't just ask for testimony. It asked for contemporaneous notes. That means handwritten notes, calendar entries, meeting summaries, text messages saved as screenshots. It means the stuff that exists before lawyers can clean it up. And there's one detail in the order that tells me the judge is looking for something very specific. The judge requests production of communications related to scheduling, travel, and coordination. Travel, coordination, scheduling. That's not random. That sounds like a case where someone claimed they were not involved or not present or not aware. And the court is saying, prove it. Show me where you were. Show me who you talked to. Show me what you arranged. Because when you track travel and coordination, you track intent, you track planning, you track who was in the room, and you track who wasn't supposed to be. Now, here's where it gets even more intense, because buried in the filings is a reference to a location, Suite 18B. No explanation, no context, just Suite 18B. And when you see something like that, you know what it means. It means there was a meeting, a private one, and the court has been told something about what happened there. And it wants to hear it from someone who was physically present. Now, I'm going to tell you what one insider described to me as the core fear inside Trump's legal orbit right now. It's not the testimony itself. It's the order of testimony, because the order matters. If you call the wrong person first, the whole story collapses. If you call a staffer first, they might reveal what the higher-ups wanted hidden. If you call a lawyer first, you risk privilege fights, but you also risk something worse. You risk a judge deciding the privilege is being abused. And when a judge thinks privilege is being used as a shield for misconduct, that's when courts start making decisions that shock people. Now, the judge's order includes a phrase that should make every lawyer in that building sweat. The court will not tolerate delay tactics disguised as procedural disputes. That is the judge saying, I see what you're doing, and I'm not buying it. So the strategy of endless motions, endless objections, endless scheduling games, the judge is cutting through it. Now, what exactly is the testimony about? The filings hint at two competing narratives. One side claims certain communications never happened. The other side claims they did, and that there are receipts. And tonight, I'm going to tell you what those receipts look like, because the receipts aren't dramatic in the Hollywood sense. They're dramatic in the bureaucratic sense. They're small, they're boring, and they are lethal. One document referenced in the filings is a call log, time-stamped, numbered, with durations, and it shows a cluster of calls on a single date, October 17th, between 6:03 p.m. and 8:41 p.m. Not once, not twice, repeatedly. Short calls, long calls, missed calls, calls returned. That pattern matters because when someone says, I had no involvement, but the call log shows repeated contact, that's not a coincidence. That's coordination. Now, another piece of evidence mentioned is a draft statement, not the final statement, the draft. And drafts are where the truth hides because drafts show what someone wanted to say before it got cleaned up. And according to the filing, the draft statement includes a line that was removed before publication. It originally read, "We were aware of the plan and took steps to ensure compliance." And the final version, "We were not aware of any plan and acted appropriately." Do you see the difference? One admits knowledge, the other denies it. That's not editing for clarity, that's editing for survival. And the judge knows that because the judge ordered production of drafts, edits and internal review comments, which means the court wants to see who changed what and when. Now, there's also mention of a recording, not a public recording, a private one, a voicemail. The filing references audio evidence of contemporaneous acknowledgement. That phrase is terrifying because acknowledgement means someone admitted something in the moment, not after the fact, not after lawyers, in the moment. And if that voicemail exists, and if it gets played under oath, then the entire defense strategy shifts instantly. Because under oath, you can't unhear your own voice. Now, I want you to understand why courts love audio. Audio doesn't blink. Audio doesn't forget. Audio doesn't misremember. If the voice matches, the words are there. And in a case like this, a voicemail can be more damaging than 100 pages of legal arguments because a voicemail reveals tone. It reveals urgency. It reveals fear. It reveals intent. Now, I want to zoom out for a second because Trump's legal strategy has always had two layers. Layer one is what the public sees, the press conferences, the defiance, the confidence, the performance. But layer two is what happens behind closed doors, the private memos, the internal correspondence, the contemporaneous notes, and that's where this judge is going. That's what makes this different. The court isn't interested in what they say. The court is interested in what they did. Now, here's where the Supreme Court enters the picture. Because when lower courts start forcing testimony, it signals that the conflict is moving from abstract arguments into factual reality. And factual reality is where appeals become harder. Appeals love legal questions. Appeals hate messy facts. And if this case climbs, if it touches constitutional claims, executive authority, immunity arguments, then suddenly you're in the Supreme Court's orbit. And that's when the stakes go national. Because the Supreme Court doesn't just decide a case. It decides a precedent. It decides what future presidents can do. It decides what limits exist and what limits don't. So when you see a judge forcing testimony like this, you have to ask, is this building toward something bigger? Is this building toward a Supreme Court showdown? Because if it is, then what we're watching isn't just legal drama. It's institutional collision. Now we move into the analysis. You have to ask why this judge moved now. Why not last month? Why not next month? Why now? And the answer is simple, because the judge believes time is being used as a weapon, delay as strategy, confusion as cover. And when courts see that, they react, they tighten deadlines, they demand testimony, they force the truth into daylight. And you have to ask another question. What is Trump's legal team really afraid of? Is it the testimony, or is it the documents that will be shown during testimony? Because testimony without documents is one thing. Testimony with documents is a trap. A witness says, I never saw that. And then the lawyer says, let me show you Exhibit 12. And suddenly the witness is staring at their own email, their own text message, their own calendar invite, their own words. And that's where people crumble. Now, if this were anyone else, would we even be debating it? If a normal public official faced an order like this, the story would be, the court is demanding answers. But with Trump, it becomes politics, narrative, spin, and that's the danger. Because the law doesn't care who you are. The law cares what you did and what you can prove and what you can't. Now, let's talk about the moral stakes, because this isn't just about one man. It's about whether American institutions still have teeth, whether courts still have authority, whether official records still mean something, whether internal correspondence still counts as evidence, even when the people involved wish it didn't exist. Because if the courts cannot compel truth from the powerful, then the system becomes optional. And if the system becomes optional, then democracy becomes fragile. Now we come to the resolution. Here's what we know tonight. A judge has demanded testimony. Not optional, not negotiable. Testimony under oath, backed by demands for contemporaneous notes and internal correspondence. The court is looking at timelines, coordination, travel, and communications. There are call logs, draft statements, possibly audio evidence. And Trump's legal team is not acting like a team that's relaxed. They are acting like a team that sees the ground shifting beneath them, because testimony changes everything. It forces the story into a place where spin can't survive. And if the documentary record contradicts the narrative collapses calmly, quietly, in black and white. So watch what happens next. Watch who shows up. Watch who asks for delays. Watch who suddenly claims they can't remember. And watch what the court does when the answers don't match the records. because the next phase of this isn't going to be fought on television. It's going to be fought in transcripts, in exhibits, in sworn statements, in official records. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter, because it does.